I've never seen that happen in a murder case where you have so many and murder cases expert testimony is important in those cases.
The judge gave them multiple opportunities to comply.
Yeah.
It wasn't like one discovery deadline they failed to meet.
Typically grounds for mistrial if a prosecutor gets up and says, hey, he exercised his fifth. To a certain extent, that can be grandstanding. You want to talk a little bit about some news in the criminal law world?
Sure. Want to start off with Linda Stanley?
So let's start off with Miss Stanley. So we got a complaint filed against her, I think it was the end of October, right?
Yeah, I think so.
Okay. Which was filed by OARC, which is the Office of Attorney Regulation Counsel. They're the administrative body that oversees all attorneys in the state to make sure that we're abiding by the professional standards set forth in different regulations. Ms. Stanley is the elected district attorney for the 11th Judicial District, Fremont County, a couple other counties down there. And she runs into a whole bunch of problems in her prosecution of the Barry Morphew case.
Yes, she certainly did.
A big case. I mean, that was one that, at least the disappearance of Mr. Morphew's wife, Suzanne Morphew, happened even before Miss Stanley came into office. And then she gets elected, and that's really her flagship case. She's pretty personally involved in that one.
Yeah, she was pretty dedicated to the case, especially with regards to its coverage on YouTube. She seems
and not dedicated to the prosecution of the case, dedicated to the public dissemination of protected information about the case.
Yeah, she was certainly trying to get her side of the story out prior to it being in front of a jury without the protections, which is why this complaint originated.
Okay. So the Office of Attorney Regulation Counsel charges her with 7 different claims for violating the rules of professional conduct. Number 1 was this failure to act with reasonable diligence and promptness. What can you tell us about that one?
Yeah, she... The trial court in that case set several deadlines in order for the prosecution to turn over discovery to defense, and she just kept missing those deadlines, which is not acting with promptness and diligence.
And it was what I thought was really interesting is, contrasting from the first case we talked about, this was stuff where the case was set for trial. They were getting within 35 days of trial. And there's just this continual failure by the prosecution to disclose expert CVs, which are, resumes. And pretty basic information that any expert should provide you early on in the case. The fact that that's coming out late, they're not sending out expert opinions or expert reports when they're re-interviewing them. All of this stuff seems to be sitting in some DA file for a long period of time before it's being disclosed.
Yeah, and I think they originally endorsed 16 expert witnesses in this case, and of those 16, 15 of them either were not allowed to testify at all or had some of their testimony limited based off of those failures to disclose that evidence.
I've never seen that happen in a murder case where you have so many and murder cases expert testimony is important in those cases. They're largely, especially when you don't have a body, which they didn't in this case.
Or a weapon.
Or weapon, yeah. That's pretty significant that you're going to need some experts to do an analysis and, make some inferences, which only they can do. The fact that at the end of the day they only left with one expert was pretty significant sanction. And I know judges are pretty reluctant to, suppress evidence in these big murder cases unless they absolutely have to.
The judge gave them multiple opportunities to comply.
Yeah.
It wasn't like one discovery deadline they failed to meet. It was multiple ones they continually failed to meet. It was a pattern.
When the rules around that even say that a court's supposed to impose, the least restrictive sanction when it comes to discovery. So I think that really means that the judge was just at the end of his rope in this case when it came to these different expert disclosures. So that's count 1. All of those experts get suppressed, didn't act diligently and promptly to get those reports out. Count number 2 is when we get into these extrajudicial statements that Ms. Stanley's making, and the prohibition is against making those statements if they're likely to prejudice a proceeding if the lawyer's participating in a case. And so that's not a prosecution-specific one. That's a general lawyer-specific one. But if you're participating in a case, you're not supposed to be making these statements outside of court that are likely to unfairly prejudice the case.
That's a reasonable rule. We don't want attorneys on either side influencing the jury before they're even seated.
So as far as this claim goes, a big one is that at the start, she's doing a press conference and makes a statement about Mr. Morphew exercising his Fifth Amendment right to remain silent.
Yeah, you as a prosecutor, you generally shouldn't be commenting on someone's right to remain silent in a press conference or even to a jury. Oftentimes, courts do not allow prosecutors to comment on someone's Fifth Amendment right.
Yeah, I've seen that, pretty standard blanket prohibition in every case, and it's typically grounds for mistrial if a prosecutor gets up and says, hey, he exercised his fifth. That's, to a certain extent, that can be grandstanding because you're kind of implying that because they chose to exercise the Fifth Amendment right, they had something to hide. Judges don't let you get into that. And so when she's talking to the media about that, she knows that information is going to get widely disseminated. I mean, she's talking to the media for a reason, so that's going to prejudice the proceedings.
Yeah, and it cuts against defendant's right to be presumed innocent, which the judge should instruct the jury over and over again that they're presumed to be innocent.
That's another thing I saw that she left out of any of her comments that she did in all these different press tours. She never, at any point that I saw at least, came out and said, look, at this point he's presumed to be innocent. That presumption's going to stay with him. He's got his right today in court, that kind of stuff. I almost always see that whenever a district attorney is doing a press conference on a large case. They normally bookend their statements with starting off by saying, hey, at this point, this person's presumed innocent, and they end it that way because, that protects your prosecution of the case. You don't want to overturn it on appeal because you made a bunch of adverse pretrial statements. So you think that's beneficial to both the defense and the prosecutor.
Yeah, nobody wants to try a case once if you don't have to, much less multiple times due to mistrials. And no attorney wants their name on an AORC complaint.
True. So the other one they mentioned is that she gets into the comment section of a YouTube video that she appeared on. Looks like she made multiple appearances on this. It's called Profiling Evil, like kind of a true crime YouTube video series, but starts to kind of defend her case against people who are saying that she's going to have trouble proving it because she doesn't have a body.
Yeah, she makes reference to other cases where people have been convicted without a murder weapon, without a body. I think she references 2 cases in particular, which is quite prejudicial to the defendant as well.
Yeah, I mean, recent cases in Colorado, so, kind of putting the defendant's case in the same camp as those other cases, same things likely to result in some pretty adverse pretrial prejudice. Last one, somebody asked her at one point, hey, do you think Mr. Morphew's going to flee? And she goes, possibly.
Yeah, I don't know if that's a wise decision on her behalf either.
It didn't seem like she had, other than the charges, which are serious, doesn't seem like she had any indication of that. But, to make that statement that he's likely to flee, again, that's you implying that, he has this consciousness of guilt, which is, what we see in actual case when people do flee, right? You can get an instruction that flight can be an indication of guilt. So her speculating that Mr. Morphew might flee, that's going to have an impact.
It certainly would on the jurors.
Then this gets into the additional rule of professional conduct, which is pretty similar to the first one, but applies specifically to prosecutors, which states that prosecutors shouldn't be making statements on that are likely to lead to the public condemnation of the accused. And so the OARC board cites that as well in their complaint. Basically the same examples again. Complaint number 4 is that she failed to properly supervise her employees.
Yeah, I think she had several prosecutors working on the case. I think Jeff Lindsay was the one running the case in particular. He was making requests for additional help on the case, and she just was not responding, unfortunately.
And that's one thing that, I don't know if people always know that, but attorneys have certain obligations but those obligations also extend to their employees and staff to abide by the rules of professional conduct as well. So if she is not putting into these procedures that discovery is managed appropriately, that they're complying with deadlines, I don't think there's an allegation that her staff made extrajudicial statements, but in a high-profile case, they're supposed to be doing these things to make sure that everyone, all the way down to a legal assistant, is complying with the rules of professional procedure.
Yeah, and this, as you were saying earlier, this is a high-profile case. It's a serious case. Her prosecutor, Mr. Lindsay, was asking for help, and she didn't even make a request for additional funds for this case at all.
We get into Claim 5, which I thought was the most harrowing one of this complaint, which it's somewhat of a mundane rule, but it's interesting how it's applied here. So it precludes a lawyer from encouraging others to violate the rules of professional conduct. Makes sense. You can't violate the rules of professional conduct. Your staff can't violate the rules of professional conduct. You shouldn't be encouraging your staff to violate the rules of professional conduct. But this really gets intense when she basically goes after the judge overseeing the case.
Yeah, she did go after the judge quite handily. She had some bad rulings, or the district attorney's office had some bad rulings. So she decided to investigate the judicial officer. I think it was his last name was Lamas. He's currently an attorney now in Pueblo. He runs a practice as well. So they tried to investigate him for domestic violence claims. First, she tells the sheriff to investigate, and the sheriff declines to investigate. So then she tasked her investigator to do it themselves from the office of the district attorney's office. So he goes and does that.
I thought that was really interesting too. So, law enforcement has to have some basis to start an investigation, right? They can't do so on a whim or a hunch or something like that, right? They need at least reasonable suspicion. And in this case, when she goes to the chief of police, says, "Hey, I'd like you to interview this judge's ex-wife to see if there was domestic violence in the relationship," the chief of police tells her that he can't do that. He says, "I don't have a basis for that." So she's already put on notice that there's no basis for it. She should know, but she's put on notice that there's no basis for that. So then she tasks her investigator in the DA's office, her employee, to go out and interview the judge's ex-wife to try and, I guess, hang him up on some kind of domestic violence allegation so he then has to recuse from the case because she was upset that all of her experts got suppressed. And the interesting part is they included in the OARC complaint the interview with the judge's ex-wife, which is that, nothing happened. There was no domestic violence in the relationship at all. So that was about as extreme as I've seen a DA go into, investigating a judicial officer. That I don't think I've ever seen that happen outside of, them getting charged with a DUI or something like that. But for the DA to institute that without any basis was particularly intense. So they get in this additional claim based on her trying to get her employee to violate the rules of professional conduct. And then she does this not only in the Morphew case, but also the last two claims are about her making extrajudicial statements in a child abuse case.
Yeah, so the Morphew case ultimately got dismissed because they couldn't prove their case because they lost all their experts. They didn't have a body. They didn't have a weapon. Mm-hmm. So she unfortunately had to dismiss that case. But then she gets another case, another high-profile case with child abuse allegations involved in it. And she goes on to make comments to the media again, not learning her lesson from the Morphew case.
I thought that was an interesting point there too. So, she's going on this YouTube channel. She's going off on people who are commenting about how the lack of a body is going to affect her case. And she's saying how provable it is because these other people got convicted. But then right before trial, the DA's office dismisses their own case by saying, "Hey, we don't have a body. We think we might be able to find one. We got to wait until the ground thaws in the spring." So they dismissed their case without prejudice, with obviously the intent to come back later on and refile it, which it's possible to do. But if they do that, and I think they found Suzanne Morphew's body recently, so they might come back and try and refile the case. But they're going to run into some issues with a Rule 7 requirement that they have to prove that, additional evidence now exists, which didn't originally, and, they'll have the new body. But I think, some of those sanctions are probably going to stay in place. Those rules are designed to keep a prosecutor from continually rearresting somebody and getting multiple bites at the apple and prosecuting them. Certainly if the purpose for her dismissing the case was because, her experts got suppressed, she's not going to get to come back later on and bring those experts back. So I guess that'll be interesting to see what happens if he gets recharged and they try and bring back those old experts. I mean, I think the defense is going to have a lot of motions to file.
May even have a venue objection as well.
So after all of this happens with the Morphew case, we've got additional claims against Ms. Stanley in her prosecution of a child abuse case where she's doing a lot of the same stuff, similar claims about extrajudicial statements and special obligations of a prosecutor, getting to the point where she's talking about the defendant's prior juvenile history. She's speculating about a motive, talking about prior uncharged conduct. I mean, all kind of stuff that you'd at least need to file a motion for before you could get into it in an actual trial, and certainly not stuff that was public before she made those statements.
Yeah, she's litigating the case before a jury has even sat. She's saying things like, why is the boyfriend watching the child? Making wild claims.
So what's your prediction about how this complaint's going to go?
I think Miss Stanley may no longer have a law license.
So that's if proven, and the OARC still has to prove their case, but if proven, then sanctions can include suspension, but all the way up to disbarment.
Yeah, she might survive the disbarment phase, but I don't think she's going to be the DA in the 11th much longer. Yeah,
that'd be an interesting election. She'd certainly have an Achilles heel there. The other thing that struck me is this isn't, at least not the first public censure against Ms. Stanley on her attorney page on the Supreme Court website. She's got a prior public censure from 2019. It looks like she was doing some kind of civil work before she became a hearings officer for the Department of Revenue. And basically when she gets that job as a hearing officer, she just kind of abandons a client, doesn't tell them that she's withdrawing from the case, waits a long time to withdraw. Client's case is set for like a 3-day jury trial. And then in order to get her motion to withdraw granted, she includes a bunch of protected attorney-client communication in her public motion. So that led to a public censure. Having a track record of that kind of misconduct is probably not going to bode well, or at least be relevant in the board in deciding whatever sanction they think is appropriate.